YouTube, Facebook, RDAP Dan here, Federal Prison Time Consulting. As you can see, we've got the amazing Tom Root with us once again. Good afternoon, Tom. Happy lunchtime to you. How you doing?
Hey, Dan. Good to see you. It's snowing here.
Is it really?
Yeah, it is. We're under snow warning, 3 to 5 inches. Nice way to introduce December to Northern Ohio.
Well, you enjoy your snow, Tom. I'm going to take my sunny Palm Beach weather best I can. We're going to give everybody a few minutes to join us. And while we're doing that, today we're going to be talking about none other than COVID-19 once again in the BOP. But today we're going to be going over some topics. BOP's hit some new records with COVID-19. We're also going to be talking about vaccines as it's supposedly maybe going to be released before Christmas time, what that looks like for potential inmates. And also, as we've seen a lot of these responses now from the government when individuals when they exhausted their remedies in the BOP through CARES Act, we're also now seeing a lot of responses from the government when filing motions for compassionate release. And I want to talk a little bit about the government's responses and get Tom's input on that, because I have my own opinion on this, but I would love to hear, Tom, your opinion on why and how the government responds the way that they do. So we're going to give everybody about 10 more seconds. We've already got 15 people in the room, which is amazing. I want to apologize for taking such a hiatus off of YouTube. I've done some traveling. It was my birthday a couple of days ago. Shelly and I are probably going to be moving to South Carolina, Greenville area. So just got a lot of things going on. So welcome. It's been the first video in several weeks. So I appreciate you guys hanging out, waiting for me. Tom, I received a lot of emails and text messages from people asking me if I was okay. Some people thought I was got in trouble, or maybe like I had some kind of a downward spiral, or I'm back in the feds. Nope, all's good. I'm back to normal. Still living in here, South Florida. So let's jump into this. Tom, where do you want to start with these topics? And I see people already posting questions in the room. I'll throw the questions up on the screen so Tom can see them, and he'll kind of answer them as he can get them in where he can fit them in.
Okay. Where would they like to begin? Are they giving people home confinement because of COVID-19? Yes, the BOP is continuing to do that under the CARES Act. We don't know how long.
Maybe prefaced on, are they sentencing people to home confinement because of COVID-19? So answer that in both ways, Tom, if you can.
Okay, let's talk about the courts first. No, I have not seen courts make sentencing decisions to home confinement because of COVID-19. That being said, we don't really get to see what happens in the sentencings because there are very seldom any written opinions issued with the sentencing. It's what happens in the courtroom, and the court imposes a sentence, and that's the end of it unless somebody decides to appeal. No, I haven't seen it yet with the courts. The BOPs are sending people to home confinement under the CARES Act. And of course, the $64,000 question has always been, what happens when COVID-19 finally goes away? The BOP under the CARES Act has designated a home confinement just as though it were another prison. What prevents the BOP from calling you up and saying, you know what, change our mind, come back? And the answer is nothing. When the House of Representatives passed the HEROES Act last May, an act which went nowhere with the in the Senate, there was a provision that the BOP was not allowed to take people back into an actual prison environment absent some good cause, like you went out carousing when you were supposed to be at home, something like that. The House version was that as long as you did not violate the terms of home confinement, they had to keep you there. That has not become law. And of course, to a lot of people, it suggests that if the House felt it was necessary to put that in the statute, that means without the statute, the BOP could bring you back. Yeah, that's true.
We may have individuals that once this thing rectifies itself and the cure is out there and they were given home confinement for a long period of time, they may actually be yanked back to go finish out their sentence back in BOP.
Yeah, I had worked with a guy who had close to 10 years left on a white collar. He got sent to home confinement. Unfortunately, he hadn't done any advanced planning, and he got sent to his son's place. Son's wife was not amused, and after a couple weeks of him really going nowhere, he was in the wrong state. He couldn't get any ID. He was kind of stuck on the couch. She called her congressman to complain. The congressman complained to the BOP. What are you doing sending this guy there with not giving these people any say? And that wasn't really what had happened. But as you know, it doesn't matter what really happened. What matters is what people think happened. And the BOP hates to hear from congressmen. So next thing our guy knew, he was back in the BOP. And I don't think he's going anywhere. He's going to do another 10 years. She bought him an extra 10 years in prison because she was inconvenienced with this guy on her couch.
So let's shift gears a little bit real quick, because we know there's a vaccine potentially coming. We've seen, as you see on the graph here, we're seeing, this is a graph that Tom shared with me earlier today. We're seeing that I don't know why that's
the BOP staff there.
That's a staff. I'm sorry, wrong one.
And I've we'll get to staff in a minute. You know, the one you're looking at with the blue background, this is the inmate cases, and these are active cases, not cumulative. Active cases at any one time since March 22, when, as you can see, we started at 0. We had our first spike in early May, and then it fell back down, and we had that second big spike in July. And after that, it fell down and it's hovered right around 2,000 cases, down to 1,500 cases. And as you can see, in the last month, it has taken off again. And we had the dubious distinction last Friday. We crossed the threshold. We now have more sick inmates at any one time than we had in the July peak, and certainly in the April peak. So the BOP is peaking, and if you look at that graph, it doesn't look like it's going to turn the corner anytime too soon.
And I think this was a big fear that we had as we were approaching the summer months. The fear of what happens during the winter months, when a lot of these, like flu season, that's kind of when it thrives, is through the colder months. So we're seeing, cases going back up. We're seeing a lot of economies shutting back down. BOP numbers are spiking. We've got word that there's a potential vaccine coming in. And before we talk about the vaccine, and we'll answer some of y'all questions in a second, before we talk about the vaccine, Tom, what are some of just to give you an idea for some of you that haven't maybe watched our channel before, you don't really know what it is that we do. We've got 2 primary focuses here at Federal Prison Time Consulting. We do a lot of the sentencing mitigation work, where we prepare you for the best possible outcome. We help you through personal narratives, reference letters, prepping you for your pre-sentence interview, getting you involved in community activities, basically taking you out of a situation so you don't look like every other defendant getting ready to go in front of a judge. And when I say look like every other defendant, I don't mean comparing a white collar, first time, non-violent type of a crime to, murderist or a rapist. I'm talking about comparing you to the same type of individual of a similar crime that you may have committed that has gone in front of this judge before. So creating a different atmosphere. How can we have you appear different? That's part of our primary focus. And now, because of the devastation that COVID-19 has had throughout the BOP system, Tom and I have been working very closely with helping individuals that are hitting brick walls when they're applying for relief directly through the BOP, whether it be through CARES Act or trying to get a compassionate release directly at the BOP level. Once they're getting denied or not being responded to at all, we've been working with individuals and crafting and designing a technique to help them receive this assistance. And one of the common things that I think we're seeing, Tom, is the responses from the government is very surprising to me. I mean, we all know the government doesn't necessarily play fair, but we're seeing some lies, I would say, very wrongdoing from the government, and the responses that they're providing before the judge throws down a decision on whether to give somebody compassionate release or not. Tell us some of these responses that we're seeing from the government, just to give people an idea of what they're up against when they're going to try to do this on their own.
Well, remember the George Washington family motto was the end justifies the means. I think the government sees that. The ends, of course, are to keep people in prison because that's what they do. And so the means are to use any argument, no matter how odious and how wrong-headed, and seen any number of them. Part of the problem is the cloud, and I mean the computer cloud. The U.S. Attorney's Office has its own cloud, and my evidence for that is that I have seen the same arguments, the same phraseology used in oppositions to compassionate release motions in virtually all of the 94 districts. You'll see it pop up. I've seen it pop up in Maine. I've seen it pop up in Hawaii and Florida. The same canned language about the BOP, what the BOP is doing to combat COVID. I mean, they'll do it for places that have already had incredible outbreaks. Elkton, Terminal Island, Lompoc. They'll talk about BOP's efforts to combat COVID. And they will, well, we just had a case where this fella had been in a local jail pending trial, and then got moved to a private prison in between, and then got moved to a federal facility. And the BOP, the government in its opposition, produced medical records from the first place and the third place, and strangely enough, didn't say a word about medical records from the second place. We got those records, and it's clear why they didn't say anything, because those records showed clearly this guy had a medical problem that would have justified giving him compassionate release. But I had the government argue that Beaumont Low, and you see the numbers, these are the current BOP numbers right now. Number one is Fort Dix with 268, and Beaumont Low 258 active inmate cases. And I've seen the government argue at Beaumont Low that we have it completely under control at a time when it was skyrocketing.
Yeah, and just like Tom said it earlier, these are not a tally of ongoing numbers. This is current positive versus current recovered. If you look like Beaumont Low, 710 recovered, and they've got 258 more inmates now that are under the weather. And these numbers are, I think, a month and a half ago, it almost looked like the BOP had this thing under control. Like, I was almost getting convinced. You look at these numbers now, Tom. This is it's going up very fast, very rapidly, and the responses from the government and the lack of response from the BOP, it's very convoluting.
I came across a report from Channel 9 in Washington, D.C. last week. Is a family in Washington whose loved one was at FMC Butner. That's the Federal Medical Center at Butner, North Carolina. He died of COVID in April. The family found out in August because his niece Googled him and found a news report that he had died in April. No one had told the family.
Wow.
Family is still trying to find the body. The BOP's given them one of two locations where they might have buried him, but no one's really sure. These are the people who say they have it under control.
And and love them, hate them. Even if the BOP had the absolute best of intentions, which I don't think they do, but even if they did, this is such an unprecedented experience that we're all going through that I think it would be impossible for anybody to truly have this thing under control. I mean, there's no easy solution. You obviously can't release everybody. You release every nonviolent offending inmate at the same time. And it's like, where is the structure behind this? So is this a case where the squeaky wheel kind of gets the oil? How do you position yourself?
Oh, I think so. And it's also a lottery on which of the 694 or so active federal judges you have. You can take an identical fact pattern. The inmate has an identical amount of time left, identical offenses, identical background. They're both no disciplinary history, did programming in prison, all the good stuff. One judge will say absolutely not. The other judge will say sure thing. It is ironic, given the focus of the Sentence Reform Act on ending unwarranted disparities in sentences, that you've got that it's just luck of the draw whether you're going to get out.
We're seeing these death rates go up too. That's also very alarming.
Yeah, and that's to be expected, that the death rates are going to go up. Sometimes it takes a while. We had a death I reported on in my newsletter. This fellow got sick in July. He was recovered at the end of July. He suddenly had to be hospitalized the end of August for gastrointestinal bleeding. After in the hospital for a few weeks, he went to Butner Medical, where he was in, they said, comfort care. And anyone who knows FMC Butner knows that means he was on the 5th floor, which was the story was when you went to the 5th floor, there was only one way you were leaving. And he lingered until mid-November and died. So yeah, the deaths can take a while.
So here's also something we see a lot, Tom. We see people that tell us their loved ones are labeled as a violent offender, and then they'll make a statement that they're not a violent offender. Sometimes obviously the family is completely wrong, but other times the family has been correct. And as you can see, the question I just posted up in the room here from Missy Gore. Missy, I'd be interested, if you're not comfortable talking about it in the room, you can always schedule a call with us, which there's a link in the description of the video. But if you want to talk a little bit about why you say he's not violent, or if you want to put his name here, I'm sure we can pull it up on Pacer.
I think I know exactly what the problem is here, Dan. There's been a lot of litigation in the last few years, even in the Supreme Court, on what crimes are violent and what crimes are not violent. Johnson versus United States, what's violent for purposes of the Armed Career Criminal Act, 924C, the use of a firearm during a crime of violence and what counts as a violent crime there. The courts have limited the definition of violent crime. And the problem is the BOP has a different definition. It's the same definition the BOP uses for RDAP. And as you know, Dan, I mean, if you got a gun in your crime, if you get the 2-level enhancement for possession of a firearm, it's not a violent crime for purposes of any of the federal criminal code, but the BOP treats it as violent to keep you out of RDAP. That's what's happening. The first part of Missy's question, the BOP says he is a violent offender because the BOP has a very broad definition. It is not just use of violence or threatened violence. It is any crime that carries a substantial risk of physical harm. I knew a guy who got declared a violent offender because he had a meth lab out in the woods in a mobile home. And he and his girlfriend slept there while they slept in one part of it and they had the lab in the other part. He was declared to be a violent offender because cooking meth, or however you make meth, in that mobile home carried a substantial risk that the place would blow up or burn down and kill them. So that made him violent. He didn't get RDAP for that reason. But Missy,
real quick, Missy, is your son, is he out of Kentucky Eastern District? Because if he is, I think I found his case, and I want to ask your permission if we're able to share it with the viewers that are watching, to kind of show people how we go through this and determine, to kind of see what we can see. But I have his information. Let me know if it's okay to share, Missy. I guess she's saying yes. Well, she might be saying yes to that's her son. Yes, can we share it? Just let me know in the room before I do. I don't want to make any embarrassing moves here. Okay,
while you're doing that, let me point out that Missy has accidentally conflated compassionate release with CARES Act home confinement. The BOP can deny him CARES Act home confinement, and the warden may say that we're not going to recommend you for compassionate release because you're a violent offender. Just bear in mind, for compassionate release, it is the judge's call, and the warden is not going to recommend anyone for compassionate release. The warden will not recommend his own mother for compassionate release because that's not what they do. So these people contact me and say, oh man, it's all over. The BOP turned me down for compassionate release. And I say, yeah, you and 10,000 other people. It's no problem. Can the judge release him if he committed a crime of violence? Yeah. I know of a case where someone was doing she was doing 20 years. 10 years. She was doing 10 years for hiring a hitman to kill her husband. Made the mistake of hiring an undercover FBI agent.
Oops.
Apparently, a lot of FBI agents moonlight as hitmen because these guys who get caught are always hiring undercover FBI agents.
It does sound kind of like a fun job if you're into, fucking people's lives up. It does sound a little entertaining. Tom, I'm going to go ahead and click on this this docket and let me know where you want to go once I get into the docket here. Give me a second. Docket report. So guys, I'm in Pacer right now. For those of you that don't know, you can create your own account at Pacer for free. You only pay for what you view. So like right now I'm viewing a docket here. And this is, okay, so let's see. Okay. I don't know if you can read that, Tom. Let me see if I can. Yes,
aided, abetted, commanded, induced, and procured
assault of another
person. Well, is an assault of another person a crime of violence? We're going to take it apart. Yeah, absolutely, because you cannot negligently assault somebody in crime. I mean, if I bump into Dan and knock him over because I tripped over my own feet, which happens a lot, that's not an assault. If I come up from behind him, hit him with a baseball bat, that is. So an assault is a crime of violence under any accepted definition. What he did, though, was the aiding and abetting statute, 18 U.S.C. Section 2. There is a lively debate right now as to whether aiding and abetting someone to commit a violent crime is itself a crime of violence. And the question is, can you do that without committing an act of violence? I worked once with a guy who provided a gun to someone so they could rob a bank. He was convicted of armed bank robbery with aiding and abetting attached to it because he aided and abetted by giving the guy a gun, knowing what he was going to do with it. I maintain that under the current definitions, that's not a crime of violence. Some courts go the other way. I just saw the Ninth Circuit in a decision last week, but in an unpublished one, saying that aiding and abetting is the same as the crime itself. Therefore, this guy aided and abetted a Hobbs Act robbery, and he was deemed to have committed a crime of violence. So that's why he got nicked with the crime of violence, because they take the view that okay, let's go 18-242. Okay, deprivation of civil rights. Now that's an interesting question there, because he did not plead to the crime he was charged with. They must have made a deal and backed it off to the 242. Can you deprive someone of civil rights under color of law? Yeah, you probably can without committing an act of violence. If he had been charged with or convicted of using a gun during the deprivation, it probably wouldn't have stuck. But the BOP, on the other hand, can look at the underlying conduct and say, well, there was an assault involved. He aided or abetted. What it comes down to is the BOP has made its own rule. The rule is 28 CFR 550.55. It's in the Code of Federal Regulations. And BOP is going to label him a violent offender because of the nature of the original charge and apparently the nature of the underlying conduct. Even if he just aided and abetted or hired someone to do it or anything like that, they're going to call him violent. Fortunately, that doesn't matter for compassionate release.
Missy, are you asking me for a copy of what we're looking at right now, his judgment, or because there's as you can see, there's quite a bit in there. I can't get you a copy of everything. I can get you a copy of what I'm looking at. I just need your email address. How long has he been in for? When did he go in? I see that he was sentenced on August 18th, but how much time does he have? Because, Tom, I've heard you talk to a lot of individuals, and obviously the more time that they had in, the better the chances of getting a positive outcome.
Yes, that is correct. Here, you know what? We can probably figure that out pretty fast here. Dan, do you have his BOP number?
Yeah, it's actually, I can get this thing to move here. And my screen froze. That's not good. There it goes. Register number is 22. Did you know this, Tom, that the USM number on these cases is also the register number?
Yeah, that's what it is. U.S.
All right.
Marshals signed
Yep.
that number.
22610-032.
Okay, he is due to get released on March 29, 2024. So it looks like his time, well, let's see, 48, and we're going to take off about 4.8, about 7.2 months. It looks like he may have been free until he got sentenced.
Yeah, it sounds like he was out.
Yeah.
He just went in
Nice
November
when you're
3rd.
out.
Okay. So he self-surrendered. That's actually, good and bad because he doesn't have a lot of time in. But the fact that he's such a violent offender, but they left him out to self-surrender on his own, it sounds like, somebody that's truly such a threat to the community, in my opinion, they don't normally leave you out to self-surrender.
Of course, that's that is a good indicator of how the judge might treat him when he gets there. There have been some holdings that where someone was free up until self-surrender time, that is by very definition not a danger to the community. And danger to the community is one of the standards. It's hard to, I've had cases where the government's argued that someone's a danger to the community and they self-surrendered. And the question is always, how can that be? How is it they're a danger now, but they weren't a danger then?
Right.
And
so, Missy, there's a link here. You know what? I'll grab the link and I'll put it in the room so everybody can have it. Let me get this real quick for you guys. You can continue to talk on, Tom, while I find this real quick.
Okay. I can natter on. So, yeah, when it's compassionate release, you're thinking about, don't worry about what the BOP thinks. Just worry that you've asked the warden and had the warden either turn you down or not answer within 30 days. And that's his situation there. The warden hasn't answered, but hey. Then the next question is, does he have a medical condition that makes it more likely he's going to suffer from getting COVID-19? So far, I do not believe anyone in the BOP has died who did not have a pre-existing medical condition. I've read every one of the press releases.
Had pre-existing.
I also get irritated because the second paragraph of the press release always says that he's doing however many months for, and then it lists his crime. And I keep saying, for heaven's sakes, the man's dead or the woman's dead. Let's just not even go there anymore. It doesn't matter why they were there.
Missy, does he have any issues? Asthma, obesity, COP? I mean, anything going on there with any of the relatable reasons of why he may be at high risk that you're aware of? So what do we think is going to happen when we talk about, because one of the big reasons the government, Tom, is now really coming up with their objections. And just because you see the government object, I get calls going, oh, I just saw that they denied him. I'm like, well, what do you mean he was denied? Oh, I saw the government. And that's, well, a government's response, a government's objection is not a denial. That's just the government trying to sway the judge to fall in favor as to what they want. The judge makes the final outcome, so they still have outcomes to come. But when we see these governments giving the responses of there's a vaccine coming, what do we know of the vaccine, Tom?
Okay. Well,
what's supposed to happen to the BOP?
I have yet to see the government argue in an opposition that the vaccine's coming, but we all knew a vaccine's coming. 3 separate companies have asked the FDA for expedited approval of the vaccine, and they're talking about the first one, the Pfizer one's got to be kept at 94 degrees below zero, being approved as early as December 10th. So,
here's some information. He's obese, high blood pressure. He's got cysts. Okay.
MRSA. Okay. The obese and hypertension are
Definitely
good. And the gout may be, because the gout is I believe it's a crystal urea. I don't know. I've learned a lot of medical in the past 6 months, I have to tell you. But even I had to email my daughter the other day, who is a physician in London, England, to ask her what something meant. So I haven't gotten it all down, but yeah, it sounds like he has medical conditions that would work. And obesity is, much to my surprise, it actually should be to my delight, I suppose. Obesity has become a much more convincing factor. You know, first it was a BMI over 40, which meant that you were about the size of a Macy's balloon. And then it dropped to BMI 30, which a lot of people don't have too much trouble meeting. And now they're saying BMI over, I believe, 25 puts you at heightened risk, but the real risk doesn't start until after 30. But, you know.
Yeah, I posted, it's in the, I put it in the live chat, guys, and I'll do it again real quick, because I forgot to tell you I did it when I did it. There's the link. If you want to book a consultation, Missy, that's directed at you or anyone else that wants to book a consultation, whether it's for potential compassionate release or what your options might be, or if you're in the early stages of going through your kind of pre-trial phases prior to being sentenced and you want to know what you can be doing. I had a call with a gentleman this morning. I hope he's watching right now, a young guy who's looking at some time, first time nonviolent offender, white collar crime. His attorney's leading him down the path of taking a plea deal, conspiracy. There's loan forgery, some fraud. Could also be looking at aggravated identity fraud, and that's the threat they're giving him, that if he doesn't take a plea deal, they're also going to tack that in, which for those of you that don't know, you know, aggravated identity fraud is going to hit you with a 2-year minimum mandatory in addition to whatever time you would be getting for the other crimes. And people get stuck in this mental block of, I think my attorney, it's appointed attorney, and they think it's because it's an appointed attorney that they're not fighting hard enough, that they're not negotiating hard enough. And there's really, and Tom, you can probably talk on this just a little, not to get off too much what we're talking about, but trying to explain to somebody that there's really not much negotiating that goes on. Turning down a plea deal normally in the beginning, early phases for somebody is, I think that's probably the early denial phases of where they just don't want to accept the reality that prison might be in their future, especially for a young man. This is something that we see a lot, Tom, of.
Yeah, it is. And it's funny, I wrote a little about that this morning, because you'll see in the political arena these people beating up, you know, Michael Flynn, saying, yeah, you know, the guy pled guilty to lying to the FBI twice, then tried to withdraw his plea. And I thought, man, you know, you don't have to be a Republican or a Democrat or take any position on the politics of it to understand that people plead guilty for all sorts of reasons other than actual guilt. I said it was more akin to raising the white flag in the face of an enemy with superior strength, because, you know, you'd rather get taken in captivity and get massacred. And that's what's going to happen. There is actually, there's a movement afoot now to fight what is called the trial penalty. We used to call it paying rent on the courtroom. That if you don't take a plea and say, I want to vindicate my rights, I have the right to a trial, I have all these rights under the Constitution, sure, you can do that. You'll get hammered with a lot more time. And a lot of people, it's just a dollars and cents transaction. But you're right, Dan, usually the first time someone turns it down is because they can't stand the thought of going to prison.
Yeah, I turned mine down, and you know, I got extremely lucky that they put it back on the table 2 years later. But I can tell you the emotional stress and financial stress that it taxed myself and my family. I had a federal appointed attorney when I initially started, and after I went through the whole process, and he's like, "Oh, we're going to get you a plea deal." Never knew what the plea deal was going to be until they offered it. And when he told me what the plea deal was, it was a cap of 60 months. And my guidelines, my base offense level was a 37 after departures, after, you know, bringing it down. So if you look at the guideline table on a 37, that's, you know, that's game over if you get hitting those guidelines. And they put a cap on there of 60 months. So even though my guidelines were, you know, base offense level 37 after it was adjusted, I was still looking at a whole heck of a lot of time if I had not taken the plea deal. So when the attorney offered me or when they put the plea deal on the table, I turned it down because in my mind, I could not rationalize going to prison. It just sounded 60 months, even though that was the cap, that was the most they could give me. In my mind, I'm like, that's 5 years. That's like a car term. and not many people pay their cars off before they trade them in. And I'm like, that just sounds like eternity to me. So I turned it down. I fired my free attorney, scrounged up some money, borrowed some money, took loans, and went and hired a high-priced private attorney who was telling me, we're going to do this, we're going to do that. End of the day, I ended up getting the same plea deal, but I had to beg for it. I literally had to fly back to Georgia. I had to convince the government. They basically sat me down at a table and they said, all right, Mr. Wise, you asked for an audience. Here you go. Why should we give you a plea deal? I had to sell myself on why I wanted to go to prison on a better sentence. And I basically felt like the biggest baby sitting there, telling them why they should give me a plea deal. And they eventually gave it to me, but it was the same plea deal that I could have taken 2 years earlier and started sleeping better and accepting the reality. Trying to explain this to somebody going through it right now, I understand. Just because I understand it, because I've gone through it, doesn't mean you're necessarily going to hear what I'm saying. But many of you are going to go out and get rid of your appointed attorney. You're going to go borrow money. Your family's going to mortgage their house. They're going to take money that they can't really afford and go hire you an attorney that's probably going to run you, best case scenario, 15 to 30 grand, which is no different than the federal appointed attorney you already have. And it's going to put you into some hardship because you're looking for this magic pill or this attorney to ride in on this white horse and slay the dragon. It's just not the reality. Most clients that we see that have appointed versus private end up with the same result. Guidelines are guidelines. Your crime is your crime. The only gift you're going to be given is when you cooperate to some extent, like taking responsibility for what you did. That's the only thing they're going to do is maybe not charge you with some additional charges, but you still got the guidelines. There's nothing they can really do about those guidelines. It's up to the judge once you get beyond that point.
Yeah. Vaccine. Let's talk a little more about vaccine.
Got off track.
Yeah. Oh, that's okay. I was deluged the past week or two with emails from guys saying, hey, they're telling us that we're getting the vaccine. And one guy said, yeah, the doc over at Health Services told me that by middle month, I'll have the vaccine here. Well, turns out reality is a little different. Associated Press got a hold of some internal BOP documents and broke this story a week ago, that BOP is getting vaccine among the first of the federal agencies. So they may have vaccine by third week of next month. Staff only. It's just for the staff. They say that eventually the BOP will provide vaccine to the inmates, but nobody knows when. There's a long list of people ahead of them. So, yeah, the BOP is going to have vaccine. Is it going to make any difference in compassionate release? I expect the BOP is going to argue, or the government will argue in oppositions, that vaccine's coming. But, I can point out that I worked on a case with a guy where when he filed, there were 5 cases. This was at Beaumont. The government opposed and said, they only got 6 cases here. By the time we replied a week later, they were at 35. And by the time the judge ruled on it, they were 200 some. So it doesn't take long.
So that's the argument the government's using, is that the vaccine's coming, but it's really not. It's coming in a superficial way where it's going to exist, but not going to be administered anytime soon to inmates.
Yeah. I mean, cure for cancer is coming, simply because, you look at the long arc of medicine that eventually it'll be around, but it's not going to help you if you have it now.
Here's a great question, which I don't know if you know the answer to, Tom, but will the vaccine be mandatory when it is given to inmates? Will it be mandatory or by their own choice?
That's a very good question. As you probably know, Dan, when they administer flu vaccine, inmates have a right to turn it down, and they give you a form you have to sign to turn it down. Whether they will make the COVID vaccine, I suppose, voluntary in the same way, I don't know.
In a second, we got a lot of people asking questions, Gene. We're going to answer your question next.
Yeah, I can easily come up with an argument that would hold water in court, that the BOP would force people to take the vaccine simply because the cost to the system of someone getting COVID is generally so much worse than the cost of someone with influenza vaccine.
I've seen the airlines are discussing possibly not letting people fly in the future unless they've had a vaccine, which it's still your choice, but at some point your choice kind of becomes forced on you because you become put into a corner. You can't really do anything that socially if you don't accept these vaccines. Like kids going to school, you can deny getting them vaccines, but schools and a lot of times won't bring in kids until they've had very specific vaccines. Gene had a question. This is how do you determine your guidelines for first-time white-collar crime? Wow. How do you answer that one in 30 seconds, Tom?
Okay. First time, so you figure you're going to be criminal history 1. You go to the sentencing guidelines, you look up the guideline that applies to your white-collar crime. In all likelihood, I'm going to guess that the white-collar crime is some type of a fraud. Fraud or theft of some kind, embezzlement. 2B 1.1 is the theft fraud guideline, and it is to white collar crime the way 2D11 is to drugs. It's like the universal universal solvent. You go to 2B11. You look first at how much money the government says was involved in your theft. Good example, we just had a daycare place close around here because checks started bouncing. Turned out the woman who ran the place had embezzled something like $35,000. If she got charged federally, she'd go to 2B 1.1. It's a base offense level of 6. You then look at how much of an increase in the base offense level because of the amount of money involved. Then there are all the enhancing factors. Were you in a position of authority? Did you use sophisticated means? And each one of those might add 2 levels. So before you know it, you start at base offense level 6 and you're at like 22.
Gene, also I'm posting a link right now. You can go grab it. This is the sentencing.us. I'm not going to promise this is 100% accurate because I don't know when the last time they updated this, but you can go through and kind of go through the process here and pick through the drop down, which for some reason, when I click on the drop down, it doesn't show you options, but you can go through what your crime is. It'll give you all the options to go through to get a rough idea of what type of guideline range you may be looking at. And then it would give you options in there also for like downward departures, for assistance and acceptance of responsibility. So this would be probably other than getting the information from your attorney, this might be a great way to get a starting point. So feel free to grab that link. I just posted it in the room just for you, Gene.
Yeah, I will say that he says it's based on November 1, 2018 guidelines manual. And as you probably know, the Sentencing Commission hasn't changed it since November 1.
Oh, that is November. I didn't see that on there.
Yeah. So this may not be new, but neither are the guidelines. So you should be okay. I will just warn you that especially when you're in something like 2B 1.1, there are so many enhancements that may or may not apply that it's I hate to say that I caution the kids at home from trying this, but don't think that you've got anything etched in stone when you come up with it. Eventually you'll come up with a number. Say you'll come up with your guidelines come up to 25 and you're going to enter a guilty plea. So you'll get 3 levels off for acceptance of responsibility. That gives you 22. And then your criminal history. And if you are a first-time offender, then criminal history is 1. Go to the sentencing table in chapter 5 and go down to 22 and criminal history 1. And it will tell you that you have a sentencing range of X months to X months. I don't know, maybe that's a good question.
I'll pull it up so everybody can see it, Tom.
I'll pull it up.
There we go.
You're faster than I am. I type in USSG for U.S. Sentencing Guidelines, and it takes me to Yahoo Finance for whatever company that is. Okay.
So this will just give you an idea from level 1 to 20. So you were saying what level, Tom?
Let's say she's like level. She ends up with guidelines of 22, and criminal history of 1, that comes down to 41 to 51 months. If you hadn't pled and you got convicted with a guideline 25, because you don't get those 3 levels off, you'd be at 57 to 71 months. So you can see what benefit pleading guilty. It took you from a low of 57 to a low of 41. That's what, 16-month swing.
And all y'all need to do is, if you just go on Google and type in federal sentencing guideline chart or table, you'll find, and they're all the same. Basically, this one, I pulled up one that only goes from 0 to 20, but it keeps going. And you can see from, you've got your criminal up here at the top. You got your criminal history category. You got your 1, 2, 3, 4, 5, 6. So you want to look at here. Most of you are going to be in a 1, and then whatever your offense level is, which the other link that I shared for the crime, where you can figure it out, it should tell you where you're at. And then you have your different zones, which qualify for, or recommend for probation, no probation. Your attorney should be able to give you the information without you doing all this work. But if you want to stay ahead of the game and stay involved, because you're going to find that the attorneys get overworked, overwhelmed, don't return calls all of the time, and being your best advocate sometimes is doing your own due diligence. So take advantage of these free tools that are out there.
If you want details on the guidelines, the link is USSC for US Sentencing Commission.gov. Go to USSC.gov. There's an interactive guidelines manual. And as I said, the 2018 manual is the latest one. And you can work your way through it. It is, like I say, it's an art form.
Missy, the fact, because we hear this a lot too, I've never been in trouble before. And I was talking to the gentleman I was talking to earlier, same things, and no priors, nothing. And that puts us in this state of mind of, especially you've got all your friends and family telling you, oh, you're going to be fine. They're not going to sentence somebody like you to prison. And the reality is, good people make mistakes and they go to prison. That's just as simple as it goes. The fact that he's got no priors, no seatbelt tickets, that does help him, but that helps him with his guideline range and his criminal category history. It's not going to change the crime and what the crime carries in that situation. I got to ask you, Missy, did you get the link? I put it in here a couple times for the consultation. If you didn't get it, write down my phone number and I'll post my number here. All you got to do is send me a text, 509-434-4695. There, I just posted my phone number here in the chat. This is my direct number. It's also in the link in the description. But Missy, if you can't figure out how to use the link, send me a call or send me a text and we can get you some consult here, because I know you said you don't have the money for an attorney. I don't know what an attorney would cost you. I can tell you that if Tom and I review your situation and feel like we can help you, it's probably going to cost you a lot less than what an attorney would cost you, but it is going to cost you something if you're able to get help. So it's just going to come down to that. Tom might be able to give you some free information. That's going to be enough for you to kind of try to do what you can do on your own. But it is a very involved process. And the problem is it's not, you don't just file this thing and, you hope for the best. You're going to file it. Government's going to respond adversely. You know that they're going to respond with why they should not be released. Then there's going to require a possible answer to that in order to give the judge, a full clean picture of what they're looking at. So there is some back and forth. These things, I wish they were super easy. If they were super easy, I wouldn't be using Tom to do them. I'd be over here writing these things on my spare time. There's a reason why Tom Root is involved here. And this guy, you're kind of a wizard when it comes to knowledge and the way that you recite and remember these different case laws and how you're able to pull them into play when they're needed. I think that's what really makes you a huge asset to what we do.
Well, my wife would tell you that I can never find my car keys.
Hey man, Avance, right? Good at one thing and horrible at others, but at least we're not worried about your car keys.
Yeah.
So I would say, guys, you got to just, realize that you're not going to figure all this out on your own. You've got yourself in this situation because your best thinking probably wasn't rational when it should have been. So assuming that you're just going to figure all this out, do it on your own, you don't need anybody else's help to solve your problems. That's one of the major roadblocks in life. Once you can kind of if you look at the big book and the 12 steps, the Bible, every type of positivity comes down to the same thing: is you have to give up you have to give into serenity and realize that you're powerless until you ask for help and you allow somebody else to suggest some ideas that might be able to plant your seeds in the right direction and get you going. So you got to start somewhere, and it can simply start with a free consultation to figure out what direction you should be going in, to then make an educated decision on what type of help you may need or you might want. Different strokes for different folks. There's no template method to this. Everybody's going to be a unique situation. That's why we have to spend the time of going through your individual situation, determine what roadmap might be best for you. And Tom is he's our creator of roadmaps over here. He's the blueprint guy. So he will help create this blueprint.
Okay, let me mention here, with the time we have left, a couple of decisions in the last few, actually starting late September, that have a substantial impact on compassionate release. There's a sentencing guideline that explains what an extraordinary and there you go. A sentencing guideline that explains what extraordinary and compelling reasons for compassionate release are. And it's pretty darn limited. It's sentencing guideline 1B 1.13. And that the judges haven't really known what to do with that, because it says that except for the, family factors, kids with no guardian, paralyzed spouse, about the only way you can get out if you're not dying yourself is if the BOP says that what you have is a compelling and extraordinary reason for getting out. Well, the BOP will never say that. The BOP turns down everybody. I think something like 98% of the requests to the BOP were turned down, where something like 25% of the requests to court are being granted. So what happened at the end of September in the Second Circuit is the Second Circuit said, well, the problem with the guideline is it hasn't been changed since the First Step Act, because back in the day, only the BOP could bring the motion. So saying that the BOP had to believe it was extraordinary and compelling made sense. Well, at the same time the First Step Act passed, three of the 5 voting commissioners on the Sentencing Commission, their terms expired end of December 2018. President didn't get around to appointing anybody. When he finally got around to appointing people, Congress didn't, or the Senate didn't give him any hearings. So here we are 2 years later, and the Sentencing Commission still lacks a quorum. So nothing's been fixed since November of 2018, before First Step. The court said, since the statute refers to motions brought by the BOP, or since the guideline refers to that, this means that the guideline has absolutely nothing to do with any motion brought by an inmate. That's a fairly big deal, because what it says is it's open season. The judge can do whatever the judge wants to do. And we know that, we're now trying to sell the judge on compelling reasons for sentence reduction that would never make it under 1B 1.13, but are still compelling. What do you do when I've got one where the spouse has mental conditions and mental disorders. She's unable to do anything. Another one where the spouse was had an aneurysm in 2018. She's not even allowed to cook by herself because she goes into seizures, needs her husband home. They never would have made it under the guideline, but they can make it now. At the same time, the Second Circuit said, the guideline, this guideline says rehabilitation is not a basis for compassionate release, and that's still true. But if you have another basis, rehabilitation can push you over the finish line. So we're now pushing a whole lot more on inmate rehabilitation. The guy's got no disciplinary reports. The guy's done all this programming, has a job with some responsibility, and the staff speaks well of him. All that helps, but it was like opening the door. And then the Sixth Circuit and the Seventh Circuit a few weeks ago, and that's what we're looking at, something I wrote on my blog about it. several weeks ago, the 6th and 7th agreed with the 2nd. So all of a sudden, we don't have one. We don't have one circuit hanging out there with some weird interpretation. We have the 2nd Circuit, the 6th, and the 7th. I loved it. The 7th Circuit said that the guideline says, or the statute says, any compassionate release has to be consistent with the policy statement. And since there is none, any decision is consistent with a non-existent policy statement. I thought there was a bit of zen there. But I found the 6th Circuit case especially helpful because it explains how the court is supposed to decide these things. First, you decide whether there's an extraordinary compelling condition, and only then do you take a look at the guidelines. And if you pass that hurdle, only then do you look at the sentencing factors. But I had cases where the court said they're not extraordinary and compelling because the sentencing factors count against you. And I say, no, that's not how it's done. The 6th Circuit says so. This may seem
somebody to be able to not just explain this, but because we know the government, that's going to be the government's objection. So it's going to take somebody knowledgeable enough to be able to realize that what the government's saying is not correct, to be able to explain it properly, to give that judge. Because can we count on that the judge is going to know all of this, or that is the judge really just kind of taking from what the government's saying and assuming the government's correct? I think you need to be there to be able to explain why they're incorrect.
That's the problem. I mean, there are literally hundreds of appellate decisions every week. Only a few of them are criminal. 85% of a federal court judge's, federal district judge's time is spent on non-criminal matters. Nobody can know all this stuff. I mean, people who focus, I focus on this area alone. I just saw an article about antitrust suit being brought against big tech, and I thought, man, I remember from nothing about antitrust. You just know barely how to define it. The judges know a little about a lot, but they don't know a lot about any little item. They depend on the lawyers and the briefs to develop it. And the
lawyers and the prosecutors and other agents, they know this and they use it to their effect, knowing that maybe they'll just go along with the bullshit that I'm saying without fact checking.
Oh yeah, and they will.
We need to look fact check in the court system now, Tom.
Yeah.
But hey, I gotta run here soon because I do have a call, but I do want to answer Missy Gore's last question because we do talk about this. This is something we talked about early in the call, Tom. If somebody's granted compassionate release to home confinement, I don't personally think they're going to take everybody and put them back in because that's going to be an effing nightmare. It does exist because it hasn't been said, but they have not said that they're going to do it either. If you had to wager on either way, where would you hedge your bet on this? You think they'd do it or no?
Let's not conflate things again. Apples and oranges. Compassionate release is done by the judge. The compassionate release is to reduce your sentence to time served. The judge may expand your supervised release period and put you on home confinement for some of that. But this isn't compassionate release is different from CARES Act. I think she's referring to CARES Act. Well, she's saying compassionate release because I don't think the Bureau sends you home. The Bureau can bring you back. But wasn't that Missy who asked that?
Yeah. So
she already said the BOP said no dice.
Oh, I didn't know that she asked them already. Okay, yeah. So yes, then we'll answer her question directly. If the judge gives it compassionate release, that means the judge is technically vacating the sentence and then imposing a new sentence of.
That's right.
And that can't be taken away because that's the new sentence.
Yeah. Now,
so if this one goes home, he's staying home.
Yeah, we need to say that if you violate supervised release, you can be sent back to prison. But it takes an awful lot more to violate supervised release than it takes to just piss off some bureaucrat in the BOP and have him say, come back to prison.
So hopefully that answers your question, Missy. And I think you said you got the link. So go ahead and schedule that call. Write down as many questions as you have, because many times we'll get on the call and you kind of really, no question is a bad question. The only bad question is the one that's not asked. So ask away. Don't worry about what the questions are. We'll give you an hour of time, sit there and see what your options might be. And then we'll create some kind of roadmap and a blueprint for you. Other than that, guys, Tom, Always, man. I think this one, we covered a lot of basis on this one. You all stayed very engaged for the full hour. We're right in an hour right now. We've had 20 plus people kind of maintaining. So that means that you guys are interested in this topic. Clearly, we'll be back probably the beginning of next week, because I think we're going to see a bunch of just shifting back and forth here with how this thing is going to play out. It's going to be very interesting to see what happens when the vaccine does hit, because then we can show that the government is full of malarkey. Until then, guys, please subscribe, share, like our content, comment on here if there's something you want to know about. You can leave comments in the description. That would be the best place, in the comment section, so other people can see them. I appreciate everybody sticking with us and riding with us for this time period. I've been out of prison now for a long time, and I feel what you guys are going through. I know it feels like the end of the world. I know you feel like nothing matters, and you get the suicidal thoughts and the ideas of going on the run and how no one's ever going to look at you the same. You're going to be unemployable, undateable. I promise you, it's not the end of the line unless you're looking at like a life sentence. But for those of you looking at, 3 years, 5 years, 7 years, life does go on after this. This is where you got to put in the work. This is where you got to have the right attitude. If you do the hard work now, you're going to receive the best possible outcome, and you're not going to be sitting in a bunk wondering what you could have done different. All right, guys. Thank you, Tom. I'll see you all soon. RDAP Dan, Federal Prison Time Consulting, people up in people, communities method, one day at a time. Sean Cowgill, appreciate you looking out for me. Peace, guys.